The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to give their attention, for the court is now sitting. God save the United States and this honorable court.
Good morning. We're happy to hear. My name is Diana Motz. With me, that you can see, is one of my colleagues, Judge Harris, and the other one, Judge King, is on video, but he can see you and will be an active participant as well. We're happy to hear argument this morning in number 194786, United States versus Aberrant. Mr. Kaufman, whenever you're ready. I'm sorry if I got your name wrong.
Thank you, Your Honor. No, you got it right. May it please the court, I'm Richard Krautharmel. I hail from Raleigh, North Carolina. I represent the defendant appellant, Michael Aberrant. This case started back in 2017. Mr. Aberrant was charged with being a felon in possession of firearm and ammunition and making a false statement in relation to purchasing firearms and ammunition. He pled guilty to those charges and he was sentenced in October of 2017. His guideline range was 262 to 327 months. He asked the district court for a downward variance. He based his reasoning on his age and his health problems and the fact that he was in state custody and would not receive credit for pretrial confinement on his federal sentence. The district court varied downward, but not as much as he had requested. The district court gave him a 200-month sentence. He appealed, and on appeal, this court vacated his sentence and remanded for resentencing and noted that although he received the downward variance, it wasn't as much as he had asked for, and the district judge had not placed on the record his reasons for the sentence that he gave. The court cited United States versus Blue in reaching that decision. When the case came back for resentencing in September of 2019, Mr. Aberrant again asked for a downward variance. The court again found that the guideline range was 262 to 327 months, but this time, instead of granting his request for a below the guideline sentence, the court gave him a guideline sentence of 262 months. The court stated on the record when it did that it had considered his criminal history, the fact that he was a violent and dangerous person, that he had committed acts of violence in the past, and then it listed the criminal convictions he had received in the past. In announcing his sentence, after announcing his sentence, the prosecutor quickly asked the judge if she had increased his sentence from the first sentencing hearing based on Mr. Aberrant's failure to appreciate the wrongfulness of his conduct as evidenced by the allocution he had just given. And the judge said, no, I did it because I carefully reviewed and took into consideration the panel opinion from the Fourth Circuit, instructing me to explain my reasons on the record, which I have. The sentence previously imposed was vacated, and having reviewed the pre-sentence report and reviewed the 3553A factors, I now exercise my sentencing judgment and impose a guideline sentence rather than a downward variance. The judge later issued a statement of reasons and noted that he gave the sentence he gave after reviewing the pre-sentence report and the sentencing factors in 3553A. The court noted the violent nature of the incident offense and the defendant's history of violent prior convictions. Finding the defendant to be a dangerous person, the court imposed a low-end guideline range sentence. So Mr. Aberrant appealed again, and now the case is back before this court. And on appeal, he has argued that the judge gave him an increased sentence without properly stating on the record the reasons for that increased sentence, and therefore that his sentence must again be vacated and remanded for resentencing. And
have you been a lawyer all the way through here?
No, Your Honor. I took over the case on the second appeal. He was represented.
You were not involved in either sentencing or the first appeal.
That's correct. And in fact, he had two I think he had two different trial attorneys for each sentencing hearing. I may be incorrect about that, but I didn't represent him at the trial level.
Counsel, I had read your brief as making a vindictiveness argument.
Right, and so I raised the argument that since the judge didn't properly state on the record his reasons for the increased sentence, that raised a presumption of vindictiveness pursuant to Alabama v. Smith, which cites North Carolina versus Pierce.
Well, presumption is an establishment, right?
I'm sorry, Your Honor?
Presumption of vindictiveness. That doesn't establish vindictiveness, does it?
That's correct, Judge. There is a presumption that still has to be established. And then there's case law from the Fourth Circuit that says the defendant must show that there's a reasonable likelihood of actual vindictiveness.
Yeah. Well, counsel, I thought, maybe I'm confused. I thought that your position was that if the district court increases a sentence on remand after a successful appeal, and it's the same judge, then there is a presumption of vindictiveness, and it's not established, but it can only be rebutted if the court relied on some new information, and that didn't happen here. I thought that was your argument. Is that not your argument?
That is my argument, Your Honor. I'm relying on the North Carolina v. Pierce opinion, which says that there must be events subsequent to the first sentencing hearing.
Right. So if all the judge says is I looked at the same old stuff and this time I'm coming out differently, that is not enough to rebut the presumption, because obviously a judge could always say that and then the presumption would be worthless.
That's correct. That's my argument.
Okay. And as I read the, sorry.
Go ahead.
Go ahead, Judge Motz.
No, you go ahead.
Well, and as I read the government's brief, they're not actually disputing any of that. They're just saying that's fine. But in this case, the judge actually did rely on new information, not the allocution, not the one they suggested at sentencing, but this time it's the letter from the daughter. That's what he relied on to increase the sentence. So what is your response to that? They say the presumption is rebutted here.
I disagree with the government, because the judge was specifically asked, why did you increase the sentence? And he did not say, based on this new information I heard today. He said, no, I'm basing it on, I would say it's because I carefully reviewed and considered the Fourth Circuit's opinion, telling me to explain my reasons, which I have. And if you want to say, okay, what were his reasons? Go back to what he said initially. And this is on page 55 of the joint appendix. He says, in reviewing his criminal history, it appears he's a violent and dangerous person. He committed acts of violence in the past. As his criminal record shows, aggravated battery with a deadly weapon, battery, escape from jail. I think that a guideline sentence is appropriate in this case. And that was it. That's all he gave. He didn't say, I'm basing this on the victim's allocution that I heard for the first time at this hearing or anything like that. So that's
not only that, didn't he actually say, it's like a hypothetical from an exam, because he says, that's complete. That's my thought process. Like he actually excludes the possibility that there's something else that he failed to mention. Like, this is it. This is the whole universe of things I looked at.
Right. On page 56 of the joint appendix, he says, quote, that's complete. That's my thought process. Right. They can examine it, see if it's adequate, see if it's inadequate, or give me further instructions. So he's not giving this court any room to interpret on the record that, hey, maybe some of this new information guided his reasoning here. He stated what he stated.
Well, where did the government come up with this idea about the letter from the daughter?
I'm sorry, Judge, what's the question?
I said, where did the government come up with this idea about a letter from the daughter at the second sentencing?
Well, I can't speak for the government, but I presume there's case law that says if there's some sort of objective information in the record indicating what might have guided the judge's increased sentence, that can...
Was that letter in the record? Is there a letter in the record that does that?
The prosecutor read the letter into the record, and that's on joint appendix pages 48 through 50. But even then, I would say if you look at specifically what the victim wrote, she doesn't talk about anything new until the very end. She says, I have been diagnosed with PTSD after this, and I struggle with the basic things in life because of what he did to us. And then she says, we are reminded of what he did every day when seeing the scars on Alex's body, the male victim who was shot by Mr. Aberrant. So that's the only new information that letter added. But again, the district judge never said, that's what I'm basing my decision on. So,
well, he said that's not what I'm basing my decision on. I mean, the government, to its credit, is imploring the district court judge to identify some new evidence that he's relying on. And the district court judge is saying, I will not do that. I'm not doing that. I'm basing it on the old record. And if the Fourth Circuit doesn't like it, they can tell me that.
I agree with that characterization.
Could he have based it on the opinion from the Fourth Circuit? Would that be appropriate?
There is case law that says that's appropriate. The government cited it. It is the Williams case, 444 F 3rd 250. Basically, it said there's no vindictiveness where the second sentence exceeds the first based solely on Booker having been rendered and the appellate court's mandate. So it is possible to increase a sentence based on an appellate mandate, but I don't read this court's mandate from the first appeal as having directed the judge to enter an increased sentence. It just, you need to state his reasons on the record why he gave the sentence he did.
Counsel, I think I maybe have lost something in translation here. I understand that you want us to reverse here. And I thought that the only reason that you offered was prosecutory, was vindictiveness by the district court. Do you offer some other reason?
No, it's vindictiveness because the
vindictiveness against your client, correct?
The presumption, yes, the presumption of vindictiveness has arisen and it has not been rebutted. Mm-hmm. So,
but if we should find there is no, that the presumption hasn't even arisen, then there would be nothing to rebut, right? Right.
Well, that's true, but I believe the presumption has arisen because there's nothing on the record.
What gives rise to the presumption on this record?
The fact that the judge did not.
The new sentence is within the guidelines. Matter of fact, it's at the bottom of the guideline.
But he had initially given him a below guideline sentence. And
well, he had given him a below, but the sentence where it's appealed here is a guideline sentence, and the circumstances here are pretty bad.
Well, the case law, Alabama v. Smith, says if there's an increase on resentencing, a presumption of vindictiveness arises if there is not a reason given for the increase, or it's not objectively clear from the record why the increase occurred. And North Carolina v. Pierce, which Alabama v. Smith cited.
So you want us to send it back basically for the same reason we sent the first time?
Pretty much, yes.
Get it explained again.
Right. At least if he's going to.
How many times, look at this, you said he talked about him shooting the boyfriend. How many times did he shoot him?
The boyfriend was shot 7 times.
7 times, okay. I want to get that in here.
But I'm relying on North Carolina v. Pierce, which says the increase must be justified by events that occur subsequent to the first trial or the first sentencing hearing. And this judge.
And you help me with that case then. You would agree with me, wouldn't you, that there's no evidence of what we told. If this was a movie, there would be no evidence of what we think of as the motion of vindictiveness against this defendant. I mean, the judge doesn't grant, so there's none of that.
Right. He never said on the record, I'm giving you an increased sentence because you won on appeal. No, that doesn't exist.
No, he doesn't have to say won on the appeal. I don't like you.
Or any reason like that. Now, I suppose you could say, okay, well, what if he just all of a sudden woke up and said, oh, wait, I didn't realize you're such a bad guy. I didn't realize you're such a violent man. I mean, that might be new, but then he would be, he'd be saying, I didn't consider those things the first time, which, he got reversed by the court the first time.
Counsel, I don't want to argue your case for you, but several circuits have considered that question. Is it okay if the judge just says the second time, you know what, you won your appeal, but I'm giving you a higher sentence because it just occurred to me how bad you really are. And they all say, no, you can't do that because otherwise the presumption is meaningless because any judge could just say that like that. If that's enough to defeat the presumption, there's no point in having a presumption. What you need tracking the Supreme Court's case law is something new. Either something new happened or something is newly revealed to the judge. Maybe it happened before, but nobody knew about it until then. I mean, I just don't want you giving away your case here.
I'm not, Judge. I'm still relying on North Carolina v. Pierce that says you got to hang your hat on something that happened after you sentenced him the first time. And there's nothing in the record here to show that. So that's the basis of my case.
Okay, thank you very much. I'm sorry.
Sorry, and for relief, just assuming hypothetically, if all of that is right, what is the precise, you want us to send it back and tell the judge what?
That he needs to state on the record the reasons for the sentence he's giving Mr. Aberrant, whatever sentence he gives him.
But
and it needs
I
to
thought
be
we did about that last time.
right. He stated reasons this time. He just changed his sentence and didn't base it on anything new. That's the error here. So well, it looks like I've exceeded my time on my initial argument. Do you want me to keep arguing, Judge Motz? Or?
I think it depends. If one of my colleagues has a question, maybe you could. All right. No, we'll hear from you on rebuttal then. Thank you.
I'll yield the floor. Thank you.
Ms. Brown? Ms. Brown?
I live with fear every day that this man will be released one day, scared to death of what he will do to me and or my family. I've been diagnosed with PTSD after this and struggle with the basic things in life because of what he did. Those are the words of the
Counsel,
victim in this case.
Can I ask you something, counsel? Did I misunderstand the record? I thought you asked on resentencing for 200 months. Is that not right?
It was the government's request on resentencing for the same.
Okay, then I don't understand. If you asked for 200 months, if you thought 200 months was sufficient, are you now suggesting that in light of the daughter's testimony, like that was wrong, you should have been asking for 262?
What we're suggesting is that in light of the daughter's testimony and the court's explanation, there was not a problem with the court. This was not a vindictive sentence. The court can sentence differently than our request without a presumption and certainly establishment of vindictiveness arising, and that's what we are here on.
Well, but Ms. Fritz specifically asked the district court if that was the reason. He said no.
She asked the court
about that.
Certainly. She asked the court if the defendant's lack of remorse was the reason.
No,
if his allocution.
Say that you chose to do that in part because of the defendant's allocution, his continued failure to appreciate the wrongfulness and harm of his actions.
Yes, and that's different than the victim's allocution in this case. She asked about the defendant's allocution.
But the problem is that the judge didn't just say, no, it wasn't that. He said, here's what it was. These are the things I have taken into account. And he lists some things, and the daughter's letter is not on the list. And then, just so there's no confusion, he says, that is complete, finished. So I don't understand how you expect us to read this record to indicate that actually, when he said that's complete, what he meant is that is incomplete. There's one other thing I haven't mentioned yet, and it's the daughter's letter.
Certainly. We're not asking you to read complete to mean incomplete. What we're doing is reading the two statements by the court explaining his sentence in conjunction. The finding that this defendant is dangerous and violent with a history of dangerousness and violence, in particular toward loved ones, like the daughter in this case, but citing those two previous specific examples. And the fact that when he said that was complete, he was also relying on the facts of the case and the 3553A factors, which he mentioned specifically, and that it's our position the daughter's testimony certainly speaks to, and speaks to in a way that the first sentencing couldn't accomplish without her explanation of what she's gone through and who this defendant is. That's what this is about, and that's what the daughter provided.
All right, I will stop in 1 minute. I just want to make sure as I understand your position, you are not sort of quarreling. You and the defendant basically agree. The sentence went up. That needs to be based on some new information, but that's okay because this one was. This one was based on the daughter's letter.
I would quarrel somewhat with the defendant's understanding of new information. I don't think it has to be something that has happened subsequently. I would agree with Your Honor's characterization during the defendant's argument today that it can also be something newly revealed to the court.
Right,
and I
which
think
would be the
here,
daughter's letter.
And I think that's the clearest thing, but I also think that the nature of a resentencing remand for explanation builds in that the sentence may be different, that the directive to the court is, we need to be sure you considered everything. And the way we do that is by your explanation. So I think it also builds in a fuller picture of the defendant as well. I think here the new information was the daughter, but the nature of a remand for resentencing on explanation builds in, we need to be sure you really considered everything. And so it could be a fuller picture when he's describing the dangerousness and the violence. And here, we think the victim's allocution was the biggest difference, and we think it was in a number of ways. So the cases cited by the defendant were also cited by the government about this don't establish that a sentence can never go up. That's not the case law. There's no rule against a sentence being raised on remand. And the issue is if that sentence is the product of actual vindictiveness. And the standard for that is whether those reasons affirmatively appear. So the first question is if this presumption even applies. Then if it does apply, whether it can be rebutted with that objective information.
And what would the argument be for why it doesn't apply? As I read the Supreme Court cases, they say that if on remand to the same judge after a successful appeal, the sentence goes up, the presumption applies. And as you say, that's not the end of the story. Like it can be, this presumption can be rebutted, but why would the presumption not apply here?
If the reasons affirmatively appear on the record, the presumption does not automatically apply. It applies if there are no affirmative reasons appearing in the record. We need to know why the judge did what he did. And if we know, then the presumption does not apply. If we don't,
if we know that it
does. Yes, Your Honor.
Okay.
And if
so it's sort of the same thing. Like either if there is some new objective information that explains why this sentence went up, then we're fine.
And if I'm hesitant to characterize, but yes, I think that's more or less correct. If we know why the judge did what he did, and that's often new information, but I do think in a resentencing context, it doesn't have to be. I think here we had that. But as long as we know what the judge did, what he did, if those reasons affirmatively appear, here we did indeed have new information. And so I think we don't necessarily even get to the presumption. If we do, it's a rebuttable presumption. And the way to rebut it is if there is objective information in the record that justifies the sentence. And we certainly think we have that here, even if the court wants to assume that the presumption does apply. In this case, it is, in the government's opinion, largely about the victim allocution on resentencing. And the victim allocution had several impacts. First, it made the facts of the PSR come alive. A lot of the cold facts were contained in the factual record initially, but it read things like this, quoting from the PSR. Aberrant stated, "Oh yeah, picked up a rifle and fired one round." That was the description before the court of his conflict with his daughter at the first hearing. At the second hearing, when she wrote her letter, that conflict, same event, was described like this by the victim. This was not a gun he had sitting in the house. He woke up the morning after the argument and planned to go purchase a gun and bullets, and less than 4 hours after the purchase, I was shot at. It adds context, it adds color, and it does add emotion appropriately.
Counsel, I hear your argument, but I'm still left with the court saying that didn't make any difference.
I think we may be reading it differently, Your Honor. I don't see anywhere the court says that the victim allocution made no difference. I would argue, in fact, his finding about dangerousness and violence was a result of the victim's allocution.
Whether it did, and he says no.
I read, Ms. Fritz said, in light of your decision, would it be fair to say you do that in part because of the defendant's allocution, his continued failure to appreciate the wrongfulness and harm his actions have caused? Her inquiry was about the defendant and his attitude.
What the answer is.
The answer said, I did it because I carefully reviewed and taken into account and guided by the panel opinion instructing me to explain. And that he'd reviewed the PSR, so the facts of the case, and the 3553A factors. But I don't think that erases.
That's all.
Yes.
That's my thought process. The end.
Yes, but I don't think that erases what he had already given as his explanation in that case, which is this defendant's dangerousness and violence. I read those together, certainly, to say that is consistent.
Judge Harris.
But counsel, I mean, presumably the dangerousness and violence were already apparent to him in the first sentencing, right? As Judge King pointed out, he shot at the boyfriend 7 times. This can't possibly have been news to the judge.
I actually think in some way it is. I understand that perspective, but I think in some ways he was presented as more dangerous and violent upon resentencing because the daughter's testimony, allocution, completely erased, destroyed any notion of self-defense. Now, I know the court found that more likely than not, that this wasn't, that the defendant was the initial aggressor, etc. But I think there could still be a lingering question about mitigation based on, well, these two, the son-in-law and the defendant, had a fight. I'm sorry.
Can I tell you my concern? I mean, just going back to the original Supreme Court cases here, right? There's a real concern that when a defendant brings a successful appeal and then goes back to the same judge, that is a circumstance where we have a concern, not to sort of single out any particular judge, but it is a circumstance that gives rise to a concern that that judge may be cranky about having been successfully appealed and may take that out on the defendant. So the Supreme Court establishes what it calls a prophylactic rule. It's going to be overbroad. We understand it will capture some perfectly legitimate sentencing, but we are so concerned that defendants not be penalized and not be deterred from appealing that we are going to require that if a judge wants to increase the sentence under those circumstances, it's going to have to give us something objective and something new. And it's not enough just for a judge to say, well, now I get it better. Because if that's all the judge, or now it's been brought alive to me, now there's more color and more emotion. Because if that's all a judge has to do, then defendants can have no assurance when they appeal that they're not going to be punished for it. And I just have a real concern. And I don't think we need more than that to establish a presumption. But in this case, I mean, of course I agree with you. Judges can sentence for more with a sentence higher than what the government is asking for, but it's pretty unusual, and we consider that when we're considering the substantive unreasonableness of a sentence. And so here you have someone who has successfully appealed, who is back down in front of the same judge, that I think is enough, and gets a higher sentence, higher than what the government is asking for. And, you know, the judge seems to be at pains both to say, I'm not relying on anything new, and I may be a little bit irritated about the Fourth Circuit. I don't want to read too much into what the judge has to say on this, but, you know, there's a bit of irritation about the appellate process coming through this transcript to me. And so that's my concern.
I'm certainly hesitant to read any tone or implication into a cold record. I, upon review, did not see
the United States had a representative at the resentencing, right?
Yes, Your Honor. We were represented by an assistant U.S. attorney who...
Well, she could tell you about or she could be arguing in front of us. So you can't really say, well, we can't tell anything from the cold record. You had someone there.
Certainly, Your Honor. And I don't mean that in any way. I simply mean there was nothing upon reading that stopped me in my tracks or that made me worried that that's what was happening here.
Right,
the standard we're looking for.
When I was a lawyer, we used to talk to the other lawyers in the case that had handled the case. You don't do that in the United States Attorney's Office?
Certainly, Your Honor. We are colleagues. And my understanding is the same as before, that there was nothing in this case of, I don't read nor have I heard of anger or anything to that effect. I think simply the judge was stating how this case got to be before him, the process. He did say that in the first as well. You can appeal this. In the second case, he said, I was given these instructions and that's what I've done. I've considered these things and this is what I've done. This is my complete thought process upon remand, and here's my position. I also think that in this case, there were differences.
Most of his purported position has come from you rather than him.
I'm sorry, Your Honor?
I said most of what you say is his position came from you today rather than from the judge back at the resentencing?
I believe what I've said today comes directly from what the judge said about this dangerousness and this violence, reliance on the facts of the case and the 3553A factors, including the defendant's criminal history. I think hearing from the victim also made that come alive in a new way. Something that's stale and printed in a PSR suddenly is received very differently when he's heard from a victim of familial violence by this defendant.
Well,
and then you look at the
representative from your office who was there didn't seem to think that that was the natural reaction. I mean, Ms. Fritz says, well, in light of your decision to impose a greater sentence, would it be fair to say that you chose to do that because of defendant's allocution, his continued failure to appreciate the wrongfulness and harm his actions have caused? No, says the district court. If he doesn't, I go, you know,
she was clarifying if this was a reason that he did what he did, certainly.
And she seemed to think that that was the reason. I
think that may have been. I think, respectfully reading the record, I think he did tell us the reason, and it was the dangerousness and the violence and the history of dangerousness and violence. The judge did say that, and he said it without any prompting, without any reminder of any directive he'd been given. He said, it appears he's a violent and dangerous person, and he committed acts of violence in the past, speaking specifically about past events in his criminal history where he was violent toward family members. Of his criminal history that is long, the judge singled out 2 of the 3 crimes he singled out were these violent acts toward family members, which echoes
but you can see, counsel, you can see, right, how relying on that, like, it does nothing to address the Supreme Court's concerns in these cases, because he had all of that in front of him the first time. And the first time he thought 200 months was exactly right, not more than is necessary, but enough to fully punish that criminal history. Criminal history hasn't changed. And now he's back, and the only thing that has changed is that he successfully appealed the first time. And he appealed it on the ground that the district court didn't fully explain my sentence, and it comes back, and the court's like, you want a full explanation? Fine, 260 months. Like, that looks bad.
Respectfully, I disagree that the only thing that had changed was the appeal. The other thing that had changed was hearing from the daughter, and it's the government's position that did 3 things. First, it made the facts of this case come alive in a new way, in a way that judges are permitted to consider. Second, it did make the criminal history come alive in a different way. It made the criminal history be seen in a different light. This doesn't just say this person was hit with the baseball bat and then stabbed in the back. This doesn't just say this person was pushed to the ground and threatened to have bullets shot into them. It puts a face to those experiences. And also, the daughter's allocution settled any issue, lingering, mitigating though it may have been, about whether this was at all an act of self-defense. That could have been an open, certainly.
Do you want us to, so there's this Fifth Circuit case, Resendez-Mendez, where the district court actually says, unlike this district court, the reason my sentence went up is because I'm relying on what the defendant said, his allocution, and I didn't like it. I didn't like his allocution. And the Fifth Circuit says, I'm sorry, you can't do that. That's not objective enough. Under these circumstances, the fact that this has been made alive to you in a new way, that is too subjective. If we allow that to rebut the presumption, then the presumption doesn't do anything, because any judge can always say that. So do you want us to, I mean, I assume you think that's wrong and you just want us to disagree with the Fifth Circuit?
I certainly don't think you have to agree with the Fifth Circuit. But I
think we don't, but you would.
And I know you're well aware of that. I don't think that that's a requirement we would ask this court to put on itself, certainly. But I also think that's where this objective information stopgap, even if the presumption applies, can come into play. Because objective information means if there is information to essentially support that sentence, if it's there to get to that bottom of the guideline sentence, then
the Fifth Circuit says it has to be both new and objective. New subjective won't do it, and old objective won't do it.
And we certainly would not ask that that standard be put in place here in the Fourth Circuit, and we don't think it is.
You want us to disagree? Okay.
I think that is appropriate, and I think that would be in line with your existing case law. And I think in this case, the way the presumption works here in the Fourth Circuit is that even if it applies, and we don't think it has to, but even if it does, if there is that objective information justifying this sentence as a stopgap, a backstop, then still the sentence is properly upheld. And here we certainly think there's objective information.
You talked about the counsel. It really is important for you to stop talking when the judges talk, okay? I know you're new before us, but do you understand that?
I think there may have been a technology error. I certainly will stop
I think
talking.
there is, because your lips don't correspond with your words and haven't the whole time. So
The promise.
What I was going to ask you is, you talked about what happened here is more consistent with Fourth Circuit case law on this. So what is your best Fourth Circuit case, the one that most supports what you want us to do here?
I think I would cite to the ones in our brief. And in fact, perhaps I should have said Supreme Court case law, which certainly applies across the board. But I think our position that we're asking is to follow Alabama v. Smith. And I understand, of course, that's not a Fourth Circuit case, but I meant operative law of the Fourth Circuit.
Let me try asking my question this way, because I really do have a genuine concern here, and I don't mean to belabor the point, but under your standard, and I really don't want to point fingers at any particular judge. So let's just imagine a hypothetical case. A defendant asks for 40 months, gets 60 months, appeals, says the district court didn't consider my arguments. We reverse and send it back. And now the district court sentences him to 100 months, which is still within the guidelines. Sorry, I'm just making this up. And says, and the reason is because the reason is because I've looked back. It says what the district court said here. I've looked at your PSR, I've looked at your record, and I now think that is the appropriate sentence. Is there anything in the standard you are suggesting that would protect that defendant if, in fact, the district court was just really mad about the appeal and that's why he did it? I mean, is there anything in your standard that would stop a district court from doing that, so long as the district court does not say out loud, and the reason is because you appealed?
Certainly. If the reasons don't affirmatively appear, or if there's not objective information to support that decision.
Right. So in my example, that would be fine. So let's just assume hypothetically that district court is just really, really mad about the appeal and is like, I can't believe you appealed my sentence. I gave you a really good sentence. This is bullshit. Now I'm sentencing you to more. But out loud, what I will say is I have looked back at the PSR and I see objective facts that put you at the high end of the guideline range, and that is why I am sentencing you to the high end of the guideline range based on these facts in the PSR. Your standard would give that defendant just nothing. That's the end of the story, right?
I think the affirmatively appear and objective information standards may be more difficult without new information. So in that case, that would be a different question, I think, than we have. But if there was no new information, then maybe those standards do more work than I think they do in this case. So that may be part of
I don't understand your answer. You're saying, so you do need new information.
New information, I think, is a bit of a misnomer. I think in your
I'm sorry, newly discovered or
newly highlighted, newly emphasized, newly on record, I'm not sure. I think here we don't have to reach that, and I'm not sure based on the case law how your question would come out. It may be an issue of first impression. I certainly think it's harder if there is nothing new in the record.
So your argument really does depend on this was about the daughter's letter. That's how I read your brief. I thought that was the argument in your brief.
Yes,
that this is all about okay.
Thank you. Counsel, you have any rebuttal?
Briefly, Your Honor, I would simply say that I agree with the government that an increased sentence can be based on a new reveal of old information. And perhaps there was a new reveal of old information on this record, but the district judge never linked up his reasoning to that new reveal of the old information. He never said, oh yeah, that's why I'm giving you 60 extra months, is because victim Chickalisi came in and told me her story today. And so I'm relying not only on Alabama v. Smith and North Carolina v. Pierce and their progeny, but also this court's opinion in the United States v. Blue, which says we're not going to fashion reasoning for a judge who hasn't explicitly and affirmatively stated his reasons on the record. We're going to kick it back and make him say why he gave the sentence he gave. So that's what this case boils down to. I'm asking the court to rule in my client's favor, vacate his sentence, and once again remand the case back to the district judge for resentencing. Thank you.
Thank you very much. I understand that you're court appointed. Is that correct?
Yes, ma'am.
Well, we very much appreciate your efforts on behalf of your client. Unless one of my colleagues has additional question. Judge King, I can't see you. Judge Harris doesn't look like she would have one. All right. Thank you very much.
I'm fine.
Thank you.
Thank you.
Then go directly to our next case, number 20-1483, Old
Good afternoon, and may it please the court.
Good
Joe
afternoon.
Rainsbury for the appellant, Old Dominion Electric Cooperative. This case raises the question of whether a federal preemption defense to a state law cause of action creates federal jurisdiction under 28 U.S.C. 1331. To ask that question is to answer. For over 100 years, it's been settled law that a federal defense cannot ground federal question jurisdiction. And this is so even where the applicability or not of the federal defense presents the main issue, indeed the only real issue in the case. Now, in the present case, the claims asserted in ODEC's amended complaint filed in state law are all standard state law claims: breach of contract, unjust enrichment, and constructive fraud. It's only PJM's defense to those claims in the form of the filed rate doctrine that raises any question of federal law. And because a federal defense cannot ground federal question jurisdiction, the district court lacked subject matter jurisdiction, and so should have remanded the matter to state court. Now, in light of the limited time I have this morning, I intend only to address the substantial federal question issue and rest on our briefs on the issue of complete jurisdiction and on the question of whether you can waive an argument about the well-pleaded complaint rule. So unless the court has questions on those issues, I'll go directly to the substantial federal question point. All right, well, before getting into the weeds on PJM's substantial federal question arguments, I'd like to give the court an overview of ODEC's argument. And it's really just a simple one, and it rests on four premises that we don't think are in dispute, and frankly, that we don't think are disputable. And the first premise is that in this case, PJM has grounded its federal question argument on the federal file rate doctrine. And that much is apparent from PJM's 12-page notice of removal, which injected the issue into this case for the first time, and from its legal arguments, both below and in this court. So we don't think that's in dispute. Second premise is that the federal file rate doctrine is an ordinary preemption doctrine. And where it applies, the rule derives its force from the supremacy clause. The cases on point agree, and PJM cites no case to the contrary. Third premise is that ordinary preemption is a federal affirmative defense. It is not an element of a state law claim. In asserting a state law claim, you don't have to allege the non-existence of federal preemption. That's not an element. And that was this court's holding in the Burrell v. Bayer case, and which we discussed at length in our briefs, and it was the court's holding in the recent Vlaming decision. And the last premise is perhaps the simplest one. I mean, and that's that a federal defense is not a proper basis for asserting federal question jurisdiction.
Counsel, can I tell you my concern about, I understand those arguments, but so far I feel like you have just described the dissenting opinion in Bryan. I mean, that's basically what Judge Ludig said in Bryan. And so my concern is, you know, the district court thought this case was controlled by Bryan. And your argument on appeal, as I understand it, is basically mostly just that Brian is wrong, that either the dissent had it right in the first place or it's been superseded or something like that.
Well,
Let me give you a chance to respond.
Don't you have to distinguish, Brian?
We have, yes, but I don't think we need to, because Brian predated the Supreme Court's decisions in Gunn and Grable. And as this court said in the Flying Pig case, the Supreme Court has really kind of reined in and clarified the rules for substantial federal question jurisdiction. I mean, it's clear.
Are you saying the Supreme Court overruled Brian?
I'm saying that the Supreme Court announced a standard that was more restrictive than the standard that this court used in Brian. It did not expressly overrule Brian. I'll agree with that. But I submit that if you applied the standard that Chief Justice Roberts stated in Gunn, I mean, you'd get a different outcome.
Didn't you also say that there were subsequent Fourth Circuit cases that watered down Brian, so to speak?
Well, I mean, I'll be clear. There's been no subsequent case from this court that's really cited Brian one way or the other on the substantial federal question.
Nothing from the Fourth Circuit watered down Brian. You don't take that contention. The Fourth Circuit's never.
Well, it's not expressly, but I will say that the decision
in addressing this, I think you should assume that at least before this panel, Brian is good law. Now, if it's not distinguishable, then we have to follow it. If it's distinguishable, tell us why.
Well, let me distinguish it. Sure. The first, I think the most obvious point is that this concerns an entirely different statute. It's the Federal Communications Act. This case concerns the Federal Power Act. And there has been a line of cases in the U.S. Supreme Court concerning, it's the Natural Gas Act, but the court construes that identically with the Federal Power Act concerning the filed rate doctrine that I think governs this particular case, and that's the Pan Am Petroleum case, in which Justice Frankfurter said, the fact that a contract dispute arises in the context of an industry that's heavily regulated doesn't mean that the contract claim is a federal claim. So we submit that controls this case. So you don't even have to get to Brian because it concerns an entirely different statute, which perhaps has entirely different policy considerations. And I think some courts have found that there's even complete preemption to parts of the Federal Communications Act, which no court has found with respect to the Federal Power Act. So
okay, that's your first ground. Do you have any others?
Yes, because in Brian 1, the plaintiff directly attacked a line item on the power bill that represented the federal uniform service charge. It was saying this charge is unfair. You've misrepresented what it really is about.
But that wasn't the claim. That wasn't the claim at issue in Brian. I thought the claim at issue in Brian was the one where they brought the state law claim that didn't directly attack it, and we said it doesn't matter because it amounts to an effective challenge to it. You're not directly attacking it, but you're still effectively challenging it by bringing your state law claim. So yeah, there were the two other claims were direct attacks, and everybody agreed on those. But the one that was at issue was the one that was not the direct attack. So can you distinguish that one?
Sure, and you're talking about the North Carolina, I think it was unfair trade practices claim. And this court, I think the district court in our case has mischaracterized really, because I think this court in Brian said that this was effectively a direct attack on that charge. And so it was a directed attack on that tariff.
Right, and that's what your colleague is about to say here, that this also, you are seeking recovery of expenses or costs that are barred under the tariff. So it is therefore an effective attack on the tariff in exactly the same way that this claim in Brian was an effective attack on that tariff.
Well, I will concede that that's how they want to characterize.
Well, so what's
Can
wrong
Can you
with
say why
that?
it's wrong?
I'll tell you why it's wrong. It's wrong because we specifically say, look, there's no inconsistency. This is a separate agreement concerning separate matters, and we're not saying that the tariff was unfair or unreasonable or anything like that. We're just saying that there's a separate agreement that says that in which that we want to enforce that they had promised to make us whole in the event that we do something that was not required under our agreement. And I'll tell you, this is very similar to the facts in Pan Am Petroleum, because in that case you had a federally filed tariff that dictated the price, and the federally filed tariff included this minimum price that the state of, I believe it was Kansas, had required for gas coming from a particular field. But then the parties entered into a separate agreement. They said that basically that if this minimum price gets reversed, then the producer would reimburse the purchaser for the difference. And Justice Frankfurter, looking at that, said that, well, that's just a straightforward contract claim. Now, the other side may raise, as a matter of a defense, the filed rate. But that's a federal defense. That's not an affirmative claim, and it doesn't give rise to the cause of action here. So again, I mean, that's another way of I think.
Can I ask you a question? Oh, Counsel, yes. Can I ask you a question? I'm just trying to get my hands on what is really at stake in this case, which I have trouble with. Will you just assume with me for a minute, just purely hypothetically, that I think putting jurisdiction to one side, this case is going to have to be dismissed under the filed rate doctrine, and whether it's as an affirmative defense or not. That my understanding is you can't really have a claim that depends on a side agreement outside of a federal tariff, because the tariff is the complete relationship between the parties. So just assume, you probably disagree, but if that's right, if this case is getting dismissed one way or another, why does it matter whether that decision gets made in federal court now or later in state court? What are the practical stakes of this jurisdictional question?
Well, first, we do disagree.
Right.
We think that there are strong reasons, including the recent Supreme Court decision in 10K versus Learjet, where they've relaxed this doctrine. But it matters just from a federal state court relationship perspective, because.
But how does it matter to the parties? I mean, we can worry about the federal state relationship.
Well, we obviously disagree with the district court's opinion. And in state court, this could not have been handled by a 12B6 motion. This would be a plea in bar. We'd be entitled to do discovery, and we'd be entitled to a jury. And we think the facts.
But I'm sorry, why is that? I'm sorry, in state court, you can't bring a motion to dismiss based on the filed rate doctrine?
No. If you have an affirmative defense and you want to bring it before the court, you do so as a plea in bar. And under Virginia law.
Do you think you can get a jury trial in the Virginia state court? It's interesting to me. It's interesting to me here that you started all this by going to FERC and telling them that you wanted $15 million more than the tariff would get you. And then you lost there. You went to this D.C. circuit. And you litigated there, wanted $15 million. And then you went to the Supreme Court of the United States, and you lost there. And then you came to the Virginia State Court and said, we need $15 million on these state claims. And you calculate that $15 million based on the federal tariff. That's the sequence of events here. Isn't that correct?
Well, you're correct that we went to FERC first, but we didn't base the.
All right, I'm correct that you went to FERC first. Then where did I go wrong in that recitation?
Sure. Well, FERC is not a court of general jurisdiction. It only had the power.
You lost at FERC, you went to the DC Circuit.
Yes, and the only issue before the DC Circuit was the retroactive. Yes, but the issues were very limited.
You went to the Virginia State Court. And at every stop, you asked for the same $15 million, which was over and above what you're entitled to under the tariff, which is the law of the land.
Well,
the tariff.
Again, the question for the well-pleading complaint.
Those facts are plain on any of the documents that we got. We can judicially notice all the proceedings you've been to before, and so could the district court.
If I can answer, we went to FERC because that was the easiest route, and it was the route recommended by PJM. Obviously, the simplest way of resolving this dispute was to get a waiver, a retroactive waiver of the filed rate. But FERC is not a court of general jurisdiction.
Because you were $15 million short under the tariff. You wanted a waiver, and there's a policy against waivers, or a law against waivers.
Well, the FERC does not have the power to issue a retroactive waiver. That is correct. And that was the sole basis for the FERC's decision, and it was the basis for the DC Circuit's opinion. But again, FERC does not have the power to adjudicate claims for, say, just ordinary breach of contract, unjust enrichment, negligent misrepresentation, and those claims had to be brought in a tribunal that had jurisdiction over this, which is what we did. We weren't able to get relief the easy way, so we had to go to court. Yes, I see that my time is expired, and if I'd like to reserve the remaining time unless the court has questions.
Thank you very much. Judge King, do you have further questions? Judge King?
I do not.
Okay.
I'm fine. Thank you.
Judge Harris?
That's fine.
Thank you very much.
Thank you.
Mr. Walker?
Thank you, Your Honor. May it please the court. Lucas Walker for Appellee PJM Interconnection, LLC. In Bryan 1, this court held that it's beyond dispute that a claim arises under federal law, where it seeks to alter the terms of a relationship set by a federal tariff, where it asks a court to second-guess the reasonableness of a federal agency's rate-making determination. That principle—
Well, this case is a little different, maybe not a lot different, but well, tell me this. Is the federal question a necessary element of every one of the well-pleaded state claims here?
Yes, we believe that it is.
Okay, it's an element of unjust enrichment. Now, see, I thought unjust enrichment, breach of contract, and negligent misrepresentation, which are the three claims here, could be brought without any without any federal question. They're regular, and at least in Maryland, state law claims. Is that different in Virginia? They're not state law claims?
So it depends on what the nature of the actual claim being alleged is. So, in Grable, for example, it was a quiet title claim. Usually it doesn't involve any federal questions, but the one that was being brought there did involve federal questions. And that's the case in ODEC.
But if you look at the complaint here, does it invoke a federal question? It invokes a federal defense, but I didn't see a federal question. And maybe my colleagues have both been in this field more than I have. But so tell me how you can tell from the face of these complaints that there is a federal question involved.
So first of all, under the artful pleading doctrine, just a party cannot manipulate jurisdiction or evade it just by failing to plead a necessary federal question. So I think that's part of the important background that Brian recognized. Beyond that, I think maybe one of the clearest ones is that in unjust enrichment, it is the plaintiff's burden to show as a condition precedent or an element or a threshold showing, however you would like to label it, that there's no contract in law that governs the relevant transaction. And that's because unjust enrichment is an equitable remedy. And so the plaintiff, in order to proceed in equity, has to show there's not a contract in law that would govern the relevant transaction. And in the complaint, ODEC tries to satisfy that condition to an unjust enrichment claim by saying it's not covered by the federal tariff. But of course, we just dispute that, and it's not true. But ODEC would have to show that there's not an express contract that governs that issue.
Right,
And
I think you've got a great defense.
it also can be a defense. The filed rate doctrine is, of course, a defense. But as Brian 1 explained in footnote 10, that the principle that a challenge to a federal tariff gives rise to a necessary federal question and supports arising under jurisdiction.
But this isn't, on its face anyway, a challenge to the tariff.
It is not on its face in the sense that it doesn't say the tariff is unjust and unreasonable. But in Brian 1, that was also the case. It wasn't saying that the rate that was being filed under the tariff was unjust or unreasonable or too high or too low. It was saying that certain marketing practices, certain disclosures were misleading and deceptive under North Carolina law. And this court held and reinforced in Brian 2 that that was a sufficient challenge, an attempt to alter the terms of the tariff relationship, because what it sought to do was obtain damages that would effectively change the rate that the tariff provided for. And I'd note that as the dissent in Brian 1 observed, Bell South actually conceded that the marketing practices that were directly being challenged were not themselves contained within the tariff. It was instead the fact that the damages sought would have required a refund or a different rate of something that was governed by the tariff. They created the federal question and gave rise to federal jurisdiction. And that's even more clear here because ODEC's claims in substance, despite its artful pleading, are arguing that it did not receive adequate compensation for these FERC jurisdictional tariffed wholesale energy services. It's trying to get the exact same $14,925,669.58 for the same categories of costs that FERC already held the tariff doesn't allow PJM to pay ODEC, and that ODEC conceded today, I think, would require a waiver of the tariff. And the DC Circuit said would rewrite the terms of the tariff. And that seems to me about as clear an example of an attempt to alter the terms of the tariff relationship as you can get.
Well, can I ask you a question, counsel? So we, in Brian, we have that footnote that says, look, we're not saying that every time the filed rate doctrine would apply because there's an effective challenge to a tariff cap. That means there will always be a federal question. And we cited approvingly the Fax case from the Second Circuit, where, as we described it, the plaintiff's state law claim relied on an alleged side agreement apart from the tariff. And isn't that basically what we have here, a claim that there's a side agreement apart from the tariff? And the Second Circuit, in fact, says, look, you're going to lose on the merits under the filed rate doctrine because you can't have a side agreement apart from the tariff, but that's a defense. So, we're sending it back to state court. Well, actually, they didn't have to send it back, and I can't remember why not. But they for some freakish reason in that case, they heard the case anyway, and they said, there's no federal question jurisdiction. We have jurisdiction on some other ground. The plaintiffs lose on the merits under the filed rate doctrine because you're not allowed to have a side agreement apart from a tariff. But that because they are suing under the alleged side agreement, there's no federal question jurisdiction. And we cited that approvingly in Brian. So why isn't that this case? Sorry.
So I think there are two main responses to that. The first one is with respect to the breach of contract claim in Fax. The alleged contract was on its own terms outside the scope of the tariff. It was before the parties had done business with each other. AT&T represented that it was going to file these promised rates with the FCC to make them the tariff rate, but it failed to do so. And so
doesn't that go more to the merits of like whether or not they're going to lose on their filed rate doctrine defense than to the federal question?
Well, I think it's important because the timing can matter in these things. As the Seventh Circuit explained in the Northeastern case, if what you're arguing the claim is based on is an alleged contract and alleged breach that predated any tariff relationship between the parties, any federal tariff relationship between the parties, then you may well have a very good filed rate defense, as the court recognized in the Northeastern case. But it doesn't give arising under jurisdiction because you don't have the key insight of Brian and cases like Marcus and Hill that you have a federal tariff that's in place that conclusively and exclusively defines the rights and obligations of the parties at that point in time. there's no dispute that the tariff, the PJM's tariff, was in effect for the entirety of all of this, all the events in question here, which is why ODEC previously asked to waive them and was unsuccessful in doing so. The second point on Pax Telecomunicaciones is that it didn't involve an unjust enrichment claim, and I think that does present quite different issues. In fact, Brian found it beyond dispute, like it wasn't even something that was seriously contested, that the unjust enrichment claim that was trying to get a rate different than what the tariff provided necessarily arose under federal law. It required a court to determine a reasonable rate or reasonable value of the services.
Well, does the footnote in Bryant 1 say that? Does it say, well, what we're saying here applies, but doesn't apply to, for example, an unjust enrichment claim?
So the footnote doesn't, but I believe it's on the same page. It's page 430.
But the footnote, it seems to me, was a pretty good response to the dissent that your colleague would like us to embrace, but we generally go with the majority opinions. It wasn't a throwaway.
Yes,
right,
and I think
I hear you.
And I think it's a recognition that the Bryan 1 majority recognized that a preemption defense or a filed rate defense does not give rise to arising under jurisdiction. But when you have the situation when this existing tariff already defines entirely the relationship between the parties, trying to alter the terms of that relationship necessarily presents a federal question. There is daylight. There are times, like in the Northeastern case from the Seventh Circuit, that the filed rate is a defense, but it's not a basis for jurisdiction, in part because of the timing of when the tariff relationship actually began. In addition to that, because we've been talking about elements. Now Bryan 1 itself doesn't speak directly about elements because it understands that you can't avoid federal jurisdiction by failing to plead necessary federal questions. So it asks, are you trying to change the terms of the federal tariff relationship? Are you asking a court to second guess an agency's rate making determination? And the Bryan 1 dissent actually agreed with that. If you would require a court to second guess a federal agency's rate making determination, that does necessarily raise a federal question. And it's really clear here because ODEC is not only asking to depart from the tariff rate, but to disregard FERC's determination that the tariff doesn't allow this and cannot be waived to allow it.
I actually don't understand that argument. I mean, I still think, yes, that's a defense, but I don't see how the complaint can be read to say that.
Well, one part of it is
maybe you have nothing more to add. I don't mean to belabor it. Go to argue your case.
Yeah. So artful pleading is not a get out of federal court free card, and Bryan 1 recognizing that said if what the claims are in substance doing, apart from the labels that have necessarily been put on them, is to ask the court to second guess what a federal agency has done for rate making, then that presents a substantial federal question. And it's because the value of those services that would be needed to determine damages is also a question of federal law. That can be the only.
So, and can you just close the loop for me? I feel like this must be very straightforward because you're sort of assuming it as a premise, but just explain to me, how does this complaint require us to second guess the reasonableness of the tariffs? I thought they were saying we have a way to calculate, this is a side agreement, right? Forget the tariff. You told us if you will produce energy during this polar vortex, we will make you whole for your extra gas prices and stuff like that. And please pardon, that's not like really crisp legal language, but we will make you whole for your extra cost during this time. And they say, I think, and we can they broke that agreement and we can figure out the damages, just, regular contract case. Like we relied on you, we bought this much fuel, and then we couldn't use it because you canceled the orders, and so you owe us this much money. And what does that have to do with the tariff, is what they would say. So why is that wrong?
Well, it's an attempt to get to alter the amount of compensation for these tariff services that's different from what the tariff allows. And that's the same thing that happened in Bryan. They may have thought, well, the damages that we would get would be some different amount, and that's not determined by federal law. But the effect is to change what the tariff says. And the tariff says...
So I thought part of the problem in Bryant, and tell me if I'm wrong, was that until oral argument, the plaintiffs didn't come up with a damages theory that was anything other than these rates are too high, you should lower them a bit. And then at oral argument, they came up with a theory more like the plaintiffs here, like, no, we've got a separate way to calculate damages. And we said, well, that's too late. But here they came up with it. It looks to me like they came up with something very much like what the Bryan plaintiffs came up with too late, but in plenty of time. But I may be misunderstanding.
Well, so the tariff says the amount that they get is zero, and even if we get into the details of their damages calculation, so it's the same $14 million and change that they saw before FERC in the DC Circuit, and they bring it in here. And we know that that's supposed to be compensation for these tariffed wholesale energy services, preparing to generate and generating electricity for the PJM bulk energy system. And as discussed on page 37 of our brief in footnote 9, it goes through the details of that damages calculation, which they fully disclosed before FERC, is the same rationale that's behind the $14 million judgment they have here. And it excluded costs that ODEC said represented, that were inherent in participation in organized markets as a generation provider and should not be unreasonably allocated. And so ODEC is itself trying to replicate the fact that this is a tariff system where allocations of risk are set by the tariff, and it is trying to change those terms.
So if it asked for damages of $20 million, having no relation to the tariff, the complaint would be fine?
Well, I think the problem is that what it is seeking compensation for are these wholesale tariffed energy services, preparing to generate and generating electricity in PJM's market in its status as a generation capacity resource. And the tariff says the amount is zero. And so any amount that they sought, however they sought to calculate it.
The reason I asked you that is you kept going back to the figure, the exact same figure. And I thought that to you had some significance. So that's why I was asking you, what if they asked you for a figure that wasn't that? It doesn't make a difference what the amount of damages are as far as you're concerned.
No, the answer would be the same, because it would seek to alter the tariff terms. It would ask a court to determine a reasonable rate for these tariff services. But we know it's...
Sorry.
So I understand the logic of that argument, but am I right? Like that would be, you want us to, if we adopt that argument, we're going a step further than Bryan, right? Because in Bryan, we said, we don't have to decide in this case whether just the mere fact that you're awarding compensatory damages to a party to a tariff amounts to a challenge to the tariff. Because here, until oral argument, they just came up with no form of damages that was anything other than, please give me a refund of some portion of these approved fees. They did link it to the tariff. So we said we could stop short, I think, in that case from adopting your theory, which is like, look, if you're suing for compensatory damages for any part of the activity that is regulated by a tariff, that's it. You're challenging the tariff and there's federal question jurisdiction. That's a bit further than we went in Bryan, right?
I don't think it's very much further, if at all. And it really just comes down to asking the court to determine a reasonable rate for these tariff services, which is the hallmark of what Bryan.
What question do you think we left open in Bryan when we said we need not and do not decide whether every award of compensatory damages would serve to challenge a carrier's tariff?
I think at a minimum it would cover those situations where the alleged breach predated the tariff relationship, like the Northeastern case, where the filed rate doctrine may well provide an affirmative defense, but it might not lead to arising under jurisdiction.
That's at a minimum. What at a maximum?
I think that would be a good maximum to go with too.
Indeed.
But
I don't think that's what we were talking about. It doesn't really matter because we can go further than we went in Bryan, but I really don't think that's what we were talking about. We cite all these cases that say whenever one party to a filed rate, to a tariff, seeks compensatory damages, that's enough. And we have the parentheticals saying we'll just simply bar all claims for compensatory damages because plaintiffs would effectively receive a discounted rate. And then we say we don't have to go that far in this case. So I think, well, it doesn't matter because we can go further.
Beyond that broader principle, there are narrower grounds certainly to resolve this particular case. And that's that if you're looking at just the state law elements, as ODEC would, each claim does in fact require some reference to federal law. They all require damages, and I think damages for wholesale energy services is ultimately a question of federal law. The unjust enrichment requires the plaintiff to prove that there's not a contract in law that governs the transaction. It also requires the plaintiff to prove what are the value of the services that were rendered. And when we're talking about wholesale energy services, that value is going to have to be determined by reference to federal law. The breach of contract, the breach of contract claim, as markets recognize, the only possible contract is this tariff relationship that governs the exclusive rights of the parties.
Excuse me. Can I just ask you one question? And this is, I'll give you some extra time because this is far-fetched and this is not this case. I understand that. But you always go back to your defense and the tariff. But if we have this complaint and for some reason the defendants don't have the excellent lawyers that they have here, indeed they have no lawyers at all, the state court dismisses the complaint because it's not well pled? You don't get to any dismissal until you have the defense, right? The affirmative defenses.
So as I think
I mean, the complaint in itself is okay. It states 3 causes of action.
Well,
it doesn't not invoking the tariff.
Well, I think I would disagree with that, as footnote 8 in Brian says, that the filed rate defense is not coterminous with the question of whether it's seeking to alter the terms of the tariff, and therefore gives rise to federal question jurisdiction. But I will go.
No, but you go with me on this complaint. Mm-hmm. It's not that not invoking the tariff or not. There's nothing about the tariff. They have a separate contract. I understand you don't think they can have a separate contract, but they're claiming under that asserted separate contract.
So I'll speak directly to the alleged contract here. So they say there's offer, acceptance, and consideration.
Right.
But the alleged offer that's pleaded in the complaint, this is paragraph 44 at JA28, it says that it's recorded in these tape-recorded and written communications between ODEX agent ACES and PJM. And those alleged promises, those tape-recorded and written communications are integral to the complaint. They're fairly considered part of the complaint, incorporated by reference. We presented those to the district court, those transcripts, and the transcripts suggest at most, we don't think there was any promise made on the merits, but they discuss reimbursement according to the terms of PJM manuals. And PJM manuals serve only to implement the tariff itself. They must conform to the tariff. It cannot deviate from it. So the specific offer or promise that's alleged in this complaint is one to compensate at most consistent with what the tariff allows. And that's JA 105, section 1.7.14 of the tariff that makes clear that the manuals can only implement the tariff itself. And so a promise to pay according to the manuals is bound up in the tariff itself. And you have to resolve what the tariff allows to resolve that claim. I apologize for going over.
No, I brought you over. Judge King, do you have any more questions? Judge King?
I'm fine. No, I'm fine, Your Honor.
Judge Harris?
No, thank you.
Thank you very much. We appreciate your argument. Counsel, do you have rebuttal?
Yes, just a few points. First, my friend on the other side repeatedly refers to the artful pleading doctrine. And as this court knows, the artful pleading doctrine arises only in cases where there is complete preemption. So this is a case like where somebody is claiming ERISA benefits and doesn't mention that it's an ERISA plan. In that case, where the claim has been deemed to be a federal claim, you can't, by artful pleading, get out of that. But there's no complete preemption. No court has ever held that there's complete preemption under the Federal Power Act. And in fact, that would be inconsistent with the Pan
Counsel, if that's right, then isn't Brian wrong? Because Brian took that state law claim that had no reference on its face whatsoever to the tariff and said, sorry, you still can't do that because it's an effective challenge to the tariff. So, I mean, again, I think you're kind of pushing up against Brian pretty hard here.
Well, if you look at Brian, the words artful pleading and the artful pleading doctrine occur nowhere. So the court had different ground.
Keep off the artful pleading doctrine. Just try to distinguish Brian.
Right. I mean,
sure. Yeah. Well, the holding in Brian was that this was an effective challenge to a federal tariff, and that gave rise to jurisdiction, and that wasn't
right.
It wasn't the
whether or not it mentioned whether or not that appeared on the face of the complaint. Like, it didn't matter because it effectively challenged the rate.
Why is this case different than that? Why can't you say the same thing about this case?
Well, I mean, again, for the reasons that I stated before, we're not directly challenging the tariff. We're saying that there is
effectively challenging.
We're not effectively challenging the tariff either. We're alleging a separate agreement that is independent from and not inconsistent with the tariff. Now, my friend on the other side disagrees, but that's their defense. It's not our claim. And under the well-pleaded complaint rule, you look to the four corners of the complaint.
Believe me, we understand the well-pleaded complaint doctrine. We understand. What we want you to do is to try to distinguish Brian. If you don't have anything more to say to us about that, fine. But
sure. Well, those were the points and the points in our brief that we assert that distinguish Brian. Now, turning to the unjust enrichment claim, it is not an element of unjust enrichment that you plead the non-existence of a controlling contract. You can raise that as a defense. I'll grant you that, but that's not an element of an unjust enrichment claim. So my friend has not cited any authority from Virginia or North Carolina that says that it's an element of such a claim, and that's the test for a necessary federal issue. In terms of this question about whether a damages claim necessarily means that there is a substantial federal question, that particular issue was raised and resolved in the One Oak case, the One Oak v. Learjet, and that was a state law antitrust action brought against, I think it was gas pipelines who were engaged in sort of this price fixing scheme. And the argument was, well, look, if we allow this, and that's going to affect the wholesale rates of gas, and that would be terrible, and that would be contrary to the filed rate doctrine. And the Supreme Court said no, that we'll allow a damages claim because it's based solely upon state law. And that's exactly what we have here. We have 3 state law claims requesting damages. And again, PJM is not a load-serving entity. PJM is not the entity ultimately buying the electricity. It's a pass-through entity. It organizes the market and it controls the grid. So, I mean, it's not like we're trying to change the price that PJM paid for electricity. We're trying to hold PJM accountable for wrongdoing that they did for either making a false promise or a false statement that they would make ODEC whole in the event that it did these extraordinary things, such as buying gas at 30 times what the ordinary price for gas was. I see that my time is expired. If there are no further questions, I thank you.
Thank you very much. So we'll go on to our third case, Lawhorn versus Mays. Mr. Navati. Good afternoon.
May it please the court. My name is Mark Nanavati. I represent, don't worry, I get it all the time.
Well, I'm terrible on names. So.
Yeah, I represent Officer John Edwards and Officer LaShawn Turner in this appeal. Let me just acknowledge right off the bat that this is obviously a tragic case. Any case that potentially involves the death of a citizen at the hands of the police or EMT is a tragedy in and of itself. This case goes back to an incident that happened back on January 16 of 2018 when officers Edwards and Turner were called to a mental health crisis at a lady by the name of Shauna Tunstall's house. Yes.
Hi, counsel. You know what? I am familiar, and I'm guessing my colleagues are familiar with the facts here, and you have so little time. Is it okay if I just start with a question?
Yes, Your Honor.
Okay, so I want to talk about the merits prong of qualified immunity for a minute and not the clearly established prong, because we're on a motion to dismiss, right? There's been no discovery. And the complaint alleges, and the district court accepted these allegations as plausible after it reviewed the video, that the plaintiff, who committed no crime and was unarmed and was detained only for his own benefit, was held on the ground for roughly 6 minutes, stomach down, hands cuffed behind him, face pushed into a pillow, defendants applying weight to his body, pushing down, continuing to do that as he's crying that he can't breathe, and after he becomes totally unresponsive, and that the officers at least have been specifically trained not to do this because of the precise risk that materialized here, which is that he suffocates to death. But you want us to hold that on a motion to dismiss with no discovery as a matter of law, it is impossible for that to add up to a use of excessive force?
That's what we're asking.
Am I under?
That's what we're asking, Your Honor. Yes.
Okay, and why would that be? Why would that be?
So what makes the case a little bit different than some of the other cases is this is not a situation where if we got into discovery, we would learn a whole lot more about what happened on the evening in question. As the court's probably well aware, the officers now wear these body cams and we have video.
No, but right. And the district court said that. The district court said, I understand. If the video contradicts the allegations in the complaint, then I won't credit them. But what I just read you were the allegations that the district court did credit after watching the video. And on interlocutory review like this, we can't second guess the district court's analysis of the record. We can't second guess his analysis of the video. So I don't think, I've already accounted for the video, I think, in my question to you.
Well, I mean, Your Honor, with all due respect, and I do think that the facts as set forth in the video, which really can't be disputed at this time, do not indicate that excessive force was used by either one of the officers or the EMTs at the time. I think there are a few things that the court pointed out in its findings of fact that I believe are relevant to the analysis and would allow this court to determine that there was no excessive force used on this particular evening. Some of the important facts I think that the district court, Judge Hudson, pointed out were this is not a situation where the officers came in and immediately took this gentleman down. He was counseled for about 20 minutes prior to the use of force about why they were there, why they needed to take him. They asked him many, many times to voluntarily go with them or the EMTs to the hospital. In this case, the decedent refused to do that. Once the decedent was taken down to the floor, there is not an allegation nor in the complaint, nor is there any evidence in the video that once he was taken to the ground that you have gratuitous force. Like in many of the other cases where somebody's taken down, there's no tasing, there's no jumping on his back, there's no punching, there's no slamming his head into the ground. There's none of the things that you see in many of the other cases where the courts have found there may be excessive force when somebody's taken into custody. Here, once he is secured in handcuffs, all the force is removed from him. It's not until he then begins to resist again that the defendants or the appellants in this case put their hands on him in order to try to settle him down. They check on his breathing at least on 3 occasions over the approximately 5 minutes that he's down. They are talking to him about trying to settle down. They say, we're not trying to hurt you, please relax. Again, it's a very different case than many of the other excessive force cases that this court unfortunately has to deal with once a person is placed into custody. I think we have a situation, unlike many of the other cases, where the force applied is not continuous throughout. It's not gratuitous. It's not substantial or significant, the words the other courts use. And I see I'm out of time. I apologize. I know my co-counsel are going to finish up the arguments, but I'm happy to stay on if you like. We coordinated in advance.
We'll hear from Ms. Weinberger, or Mr. Weinberger. I'm not sure about Leslie. But I would say to you, counsel, that it is important to understand, and this counts as my time, not your time, to try to speak slowly enough so that the court can ask its questions. Because after all, we have to make the decision. You know the case already. Okay.
Yes, I'm sorry.
Mr. and Ms. Weinberger?
It's Leslie Winneberger.
Yes.
May it please the court, I represent Christopher Tinley. The point that I would like to make in my small amount of time is that context matters, and it matters particularly in the case of qualified immunity. And I know that this court is well versed in qualified immunity, and it knows that it exists to protect people in these gray areas. I think one of the cases talked about the hazy borders. And mental illness often operates in that hazy border. It doesn't lend itself to an obvious response, and it makes the dynamic very unpredictable and fluid. And by virtue of the mental illness, the person is not necessarily making rational decisions or making decisions that are self-protective. And that's what this case is here. It's not obvious. My client comes in at the request of law enforcement to help. And I think the question posed for the court is really, is there a clearly established body of law that put the defendants on notice that trying to subdue a mentally ill man with obvious self-inflicted injuries for less than 5 minutes, while he's also being monitored by EMTs, was a constitutional violation? And in particular,
can I go back? So you started by saying that context matters, and I think that's clearly true, both for the merits analysis here and for clearly established. But that's why I think we have said that it's very hard to grant qualified immunity on a motion to dismiss, just precisely because the factual nuances really matter in these cases, both on the merits and also for sort of trying to figure out whether a case is squarely governed by some other precedent. And I mean, a motion to dismiss, we don't have the context yet, which is basically what the district court said. I mean, it's not like I feel like you guys did okay with this district court. You know, it's a motion to dismiss. He did grant qualified immunity on some of the claims, and on just this one, he said, look, come back after summary judgment. I'm not saying we're done with this. I'm just saying I need a few more facts. So why isn't that right? I mean, we have said that it ought to be very hard to prevail on a motion to dismiss, just precisely for the reasons you've given.
I would normally agree with your characterization. And the reason I wouldn't agree here is because we have the video. So as Mr.
Again,
can
I ask you, this question sort of, it's a jurisdictional question. So the district court reviewed the video itself, and it said, you know, where the video contradicts the allegations, I'll go with the video. But it still found, having watched the video, no, it is entirely plausible to say he was sufficiently secured. There was no reason to keep applying force. And my understanding is that on interlocutory review, whatever I might think of the video, we're stuck with the facts as the district court found them. The district court's view of the record we have to take as a given. And he watched the video and he just sees it differently than you guys do. And I don't know that we can get at that in this posture.
Even if that's the case, I think this court can still get at it because it's not clearly established law, particularly as it applies to my client, an EMT. All of the cases that have been cited by the plaintiff has dealt with law enforcement officers and what they've done in situations. And none of those situations have factual scenarios like the one we're dealing with here. And so I think that the court is not precluded from deciding that the law is not clearly established when it comes to this particular context, regardless of what the video does or does not show.
And when you say there are no cases with facts like this, I mean, I assume you mean in the Fourth Circuit, because there's a whole bunch of circuits that have looked at facts. Again, we don't know what the facts are, but rough, given the limited basis of our knowledge, facts that look exactly like these facts, and they have all held, one, that's excessive force, and two, it's clearly established that that is excessive force. So you mean just in the Fourth Circuit, we haven't looked at anything just like this?
Fourth Circuit or in the Supreme Court. Now, I know the Supreme Court just came out with a case very recently, but of course that wouldn't have been in play back in 2018. But in the Fourth Circuit there, and I see I'm out of time. If you'd like me to finish, I can. But in the Fourth Circuit, I don't think there's any cases that deal specifically with this kind of scenario. And that's the point, is my client needs to be on notice of what the law is. Otherwise,
and it's your understanding that that law has to come from the Fourth Circuit. It's not enough if there's a consensus in the other circuits.
I just don't think that that law is binding on this court.
For qualified immunity purposes, it is. We've said that anyway, if there's a consensus.
And when you were talking about that case from the recent case from the Supreme Court, that was a couple of weeks ago, was it?
The Lombardo case.
That's the name of it?
I believe it was decided, well, I just have that it was decided in 2021, but yes, it was very recently, probably within the past month.
There were a couple of them decided like 2 weeks ago without argument. I think maybe one of them is what you're talking about. Okay.
Yes, and there were 2 others, Taliqua and Rivas Villegas, that were also decided. That was actually on October 18th.
Mr. Conrad, do you have something for us?
Yes, ma'am. Thank you. John Conrad, I represent the defendant, Alex Mays, who is also an EMT person, just like Ms. Winterberger's client. And I adopt her argument on behalf of Alex Mays. The bottom line, I heard what the court had to say, but the bottom line is that that the complaint Exhibit C does contradict and refute a lot of the allegations in the complaint that the district court relied on. And we think that the district court erroneously relied on those allegations, given the fact that we have a videotape showing all of the facts of this case. But nevertheless, as with Tenley, with Mays, there is no clearly established law that gives a bright line test of warning to either Mays or Tenley about what constitutes an unlawful, unconstitutional act.
Counsel, can I ask you just a factual question? And I will totally understand. I know there's been no discovery, and maybe this question is premature, and I will understand if that's the answer. But I was wondering, there's evidence attached to the complaint, I guess, that police officers are trained about the dangers of positional asphyxiation. Would EMTs have learned along the way that if you keep a person pushed down on their stomach with their hands behind their back for a prolonged period of time while they're saying they can't breathe, that would create a risk of asphyxiation? Or I understand that we know that as to the police officers, but the record does not show one way or the other as to the EMTs. Do you have a feel for that, or should I wait? Or do we just not know that because there's no discovery?
I do not know the answer to that, but I will tell you that it's clear from, again, the allegations and the complaint Exhibit C that Mays as well as Tenley were, and this is admitted in the complaint, were assisting Officer Edwards, who made the decisions on the not only the initial detention but also the use of force after that. For example, Mays, the only thing he did, and both Mays and Tenley provided monitoring of Mr. Lawhorn during this whole episode. And as a matter of fact, on 10 different occasions, Edwards as well as Mays and Tenley monitored Mr. Lawhorn's condition in terms of breathing and that sort of thing. But the bottom line is that, positioning of of Mr. Lawhorn was being provided by Officer Edwards and not by either Mays or Tinley. For example, Mays was on his feet the whole time. And, you know, if Mays and Tinley are liable in this case, then any EMT that touches the person under this situation is going to be liable, and it's going to turn the practice upside down. In Mays's case, he touched Mr. Lawhorn for a grand total of 99 seconds over 3 minutes and 28 seconds. And that's depicted at the time marker 23 minutes to 26 minutes and 28 seconds on the video cam, and it's not contradicted in the allegations of the complaint. And it's a similar situation for Tinley. The time that these two men touched Lawhorn was minuscule. It was also proportional, and it was reasonable, and it was necessary, because after Mr. Lawhorn was initially detained in this case, that occurred at the 22-minute, 39-second mark to the 23-minute mark. Mays, Turner, and Tinley all stood up and walked away from Mr. Lawhorn. They had no intent whatsoever, after he was initially detained by Officer Edwards, to lay their hands on him. And the only reason Mays, as well as Tinley, subsequently undertook any physical restraint was because of Mr. Lawhorn's active resistance. So that, coupled with the fact that these two men had absolutely no bright line whatsoever to guide them, to indicate to them that they were guilty of any constitutional violations, is dispositive.
Well, see, that's why I asked about their training, because we have held that you can look at things like training documents and policies under the qualified immunity analysis. And it's one of the reasons I think it's hard to apply the clearly established analysis at this stage of the proceedings when there's been no discovery on any of that.
Well, if you read the allegations of the complaint and you look at Complaint Exhibit C, you will see what I'm talking about is true, and that is Tinley and Mays were role players, and it wasn't part of their role, for positioning of him in terms of asphyxia. They followed the requests of Edwards on that point and initiated nothing on their own, because Mays had initially told Mr. Lawhorn, as well as his roommate, Ms. Tunstall, that he had done, a time, purpose, and place initial evaluation of him, and that he had concluded that he could not provide services to Mr. Lawhorn because he had not consented. And he announced that conclusion to Mr. Lawhorn as well as his roommate Tunstall. The only reason...
Mr. Conrad, you've gone well over. You want to just use up your rebuttal?
If I may just add one last point.
Well, you're already used 1 minute and 22 seconds, and you only have 1 minute of rebuttal. So do you want to continue and finish, or do you want to keep your 1 minute of rebuttal?
I'll waive my rebuttal if I can have 20 more seconds.
Fine. You can have.
The last thing I want to say is that, but for the passionate request for detention by his roommate, Ms. Tunstall, Mays, Tinley, none of these appellants would be here. Listen to the words of Mrs. Tunstall responding to Mays's conclusion that he couldn't transport Mr. Lawhorn. Hell no, he needs to go out of here right now like he's behaving. I'm telling you, please, okay? I can't take care of that. Whatever that mind thing is, that mind thing is uncontrollable. If he ends up dead here tonight in this house, I did not do it, and that's the point I'm advocating, his mental state. And that's at 16, the minute marker, 16:53 second mark of the complaint.
All right, thank you very much.
Thank you for your courtesy, Your Honor.
Mr. Macbeth?
May it please the court. Good afternoon. My name is Isaac Macbeth. I'm here today on behalf of Angie LaHun, the mother of Joshua LaHun. We are requesting that the court affirm the district court's denial of qualified immunity to these appellants as it concerns their excessive force after Mr. LaHun was secured in handcuffs. Being that this is an interlocutory appeal, what is not subject to review here is the factual determinations of the district court. The district court took as true the factual allegations in the complaint, tested against the video, and after doing that, arrived at the conclusion that the defendant's continued use of force, notwithstanding Mr. LaHun's alleged resistance, ran afoul of clearly established law and was excessive. And so to disrupt that result, there would have to be an error of law, that is an error in the interpretation of the application of the facts to the law, not a misinterpretation of the video or the allegations in the complaint. And there's been no showing that the district court erred in that regard. Actually, the district court cited this circuit's precedent as it relates to the unwarranted application of gratuitous, unnecessary force to secured individuals in concluding that the complaint plausibly alleged a clearly established violation, and also cited to the authority that has been promulgated by other circuits concurring on that issue in more factually specific contexts. And so in the absence of that error, or in the absence of any showing that the district court erred in its legal application, we don't think that the appellants have met their burden of demonstrating a ground for reversal. Now, as it concerns the merits of the excessive force analysis, here it's the complaint alleges that Mr. LaHun, had committed no crime. It alleges that at the time that this force continued, he was secured in handcuffs and he was not a threat to officers, and that he was not capable of flight or resistance. And under this circuit's precedents, that arrangement of the Graham factors yields the conclusion that the application of force, particularly force that is capable of causing severe injury or death, is excessive. And this court's precedents, such as Bailey v. Kennedy and Young v. Prince George County, established that the application of force to someone who has been secured, who has not committed a crime and is no longer a threat to officers, is unconstitutional. And what I think is notable about those precedents is, in both of those cases, the gratuitous force that was held unconstitutional in no way posed risks of injury comparable to the use of force at issue in this case. So, for example, in Bailey, the constitutionally offensive use of force was jerking the plaintiff up by the shoulder after he had been secured in handcuffs face down on the ground. It caused the plaintiff a severe shoulder injury. But compare that against the present use of force, where the risk is asphyxiation and death. It just seems to me that if Bailey clearly established you couldn't use that lesser degree of force under analogous circumstances, it would be difficult to say it didn't clearly establish you could not use deadly force under analogous circumstances. And in that regard, I think that is why the district court was correct in its analysis for a second reason, which is this use of force violated the rule that deadly force may only be employed by officials where there's a requisite showing of imminent harm to law enforcement officers or those that are nearby. And it has to be an imminent threat of serious harm. It can't be something like the sorts of harms that have been alluded to in briefs, like flopping on the floor. And there's been no indication that such a harm exists. It's certainly not borne out by the allegations of the complaint. The district court did not find any indication that such a threat existed. But yet, the decedent was exposed to the use of deadly force for almost 6 minutes. And he ultimately did die of his injuries as a consequence of that. And to quote this court's language from Clem v. Corbeau, the law in 1988, which obviously predates this, provided clear guidance to a police officer that he was not free to use deadly force in the circumstance where the recipient of the force posed no threat to officer safety. And here, Mr. LaHun was handcuffed. He was face down on the ground. There's simply no realistic argument to be made from that body of facts that he posed the threat needed to exert deadly force on him.
Can I ask you a question just so I'm clear on your argument? Even if we don't treat this as deadly force, you know, with its sort of doctrinal Tennessee v. Garner meaning, I mean, we held in Armstrong something pretty similar, which was just because someone is resisting, that doesn't mean you can use force. There has to be a danger that you're addressing. So the fact that someone is struggling, if they can't actually do anything about it, does not by itself justify the use of force. So your argument here doesn't really depend on use of deadly force, given its sort of specialized doctrinal meaning, right? Like whether it's deadly force or not. Okay.
Exactly right, Your Honor. And I think that that is actually one of the points that's made in the Estate of Jones case, is that this gratuitous force on a secured individual, whether deadly or not, would have run afoul of clearly established law back in 2013, which clearly predates the facts at issue in this case. So it is not necessary to reach a finding of deadly force to still find a violation of clearly established law here. Let me look through my notes. The final point that I would like to make on the issue of clearly established law deals with the exertion of force on an incapacitated subject. That was addressed in the Estate of Jones case as well. And there, this court observed that in 2013, it would have been known to a reasonable law enforcement officer that you cannot continue to use force on an incapacitated subject. And here, the video exhibit to the complaint clearly bears out that Mr. LaHun was completely unresponsive at approximately the 27-minute mark, but yet the continued application of weight and pressure in the prone position continued for another minute and a half. And so that would be yet another basis in which this force was not only constitutionally excessive, but ran afoul of clearly established law. That largely consists of my argument, but I want to answer any questions I can to be helpful to the court, if there are any.
Well, can I ask you to address the EMTs for a minute? The district court didn't really treat them separately when it comes to the excessive force claim. But, I mean, maybe you could just address the concern that I understand some of your colleagues to be raising, which is these are not law enforcement officers, they're paramedics, and they find themselves thrust into this law enforcement situation. And so why can't they just follow the officer's lead and assume the officers know the rules?
Well, I think that the answer to the question, Your Honor, is that they can follow the law enforcement officer's lead, but that Virginia law has established that when you are aiding in a law enforcement officer in securing a subject into custody, the lawful extent of your authority is coextensive with that of the officer. That was decided by the Supreme Court in the Byrd decision. And so the law would have put the paramedics on notice, or the objectively reasonable paramedic charged with knowledge of the law would have known that their conduct in that situation would have been measured against the same standards of conduct applicable to law enforcement officers, given this was a law enforcement arrest. And in fact, on that point, the ECO statute in Virginia, which Mr. LaHun was being taken into custody under, specifically grants the authority to bring someone into custody solely to law enforcement officers. So again, someone aware of the law, of the governing law of the jurisdiction, would realize they were performing a law enforcement function in taking custody of Mr. LaHun, and that would further put them on notice that they would be judged by law enforcement standards.
Okay.
Unless there's any other questions that I can field for the court, that concludes my argument.
I don't hear any other questions. Thank you very much. Appreciate it.
Thank you, Your Honor. Thank you.
Is there any rebuttal?
Briefly, Your Honor. And I just want to point out a couple of things. There was a question earlier. I think it was Judge Harris that asked, or maybe you asked, Your Honor, about precedent in other jurisdictions and whether that would give the guidance necessary to the defendants in this case to know that the conduct that's at issue would be a constitutional violation or clearly established constitutional violation. And I guess I would respectfully suggest that many of the other cases out there cited by everybody in this case, whether it's myself or the opponents, where you're dealing with force applied after somebody's been brought into custody, is what I would categorize as much more gratuitous force than what you have here. Even the Jones case, the estate of Jones case, which Mr. Macbeth just cited. I mean, I think after they had him down, they tased him 4 times, punched him in the face and throat, threw him down a set of stairs, placed him in a chokehold, and then shot him 22 times with a gun. I don't know if that's the kind of fact pattern that would put these particular defendants on notice of what they did here was a clear constitutional violation. It seems to me if we're going to look to other jurisdictions, the Seventh Circuit opinion in the state of Phillips is almost on all fours with this. And in that case, the court said it was not a constitutional violation to do almost exactly what the defendants in this particular case did. So I would respectfully suggest that whether you're looking at the Fourth Circuit jurisprudence or jurisprudence from your sister circuits, I think it's hard to find a case that's on all fours that would allow any one of these particular defendants to know that this particular conduct, particularly given the attempt to monitor his behavior, particularly given the fact that the decedent in this case placed himself into this position, particularly given that we're talking about maybe 5 minutes, particularly that there's no gratuitous force. I don't believe there's any clear case law out there would have allowed any of these defendants to know that these series of acts or omissions would constitute a constitutional or state law violation. Thank you very much.
Thank you. And counsel, do you have rebuttal? Ms. Weinenberger?
Yes, I do. I just wanted to briefly talk about the Bird case that Mr. Macbeth had mentioned. That case was a case where a citizen was asked to effect an arrest. Here, law enforcement officers had called, emergency medical technicians to come to the scene and help. I don't think that case, Bird, would create some robust, again, consensus of authority that would have put Tinley or Mays on duty, that when they're called to provide assistance, that makes them law enforcement officers. Throughout as Mr. Conrad had already pointed out, throughout the time that they were dealing with Mr. Longhorn, Tinley was telling Edwards that he was breathing. He got a stethoscope out to check. He moved the pillow out of his face so that he would have an easier way to breathe. He actually performed CPR. He was not a law enforcement officer. And all of the cases cited, whether in the Fourth Circuit or outside the Fourth Circuit, have dealt with law enforcement officers, not emergency medical providers. Thank you, and thank you for your time.
Thank you very much. We appreciate your arguments. And we will go directly to our next case. This is number 1971, United States versus Benton.
May it please the court. In United States versus Hodge, this court held that the government must specifically identify which convictions it's relying on to seek the armed career criminal or ACC enhancement. And if the government fails to specifically identify certain convictions, then it cannot rely on those convictions for the first time on collateral review. That's what happened here. In Mr. Benton's case, the government identified a single distribution conviction as an ACC predicate, yet it asked the district court for the first time on collateral review to find 3 additional distribution convictions as supporting the ACC enhancement. This violates Hodge, and thus this court should vacate the district court's denial of Mr. Benton's 2255 motion and remand the case for further proceedings. Paragraph 64 of the pre-sentence report listed 4 separate prior felony convictions as ACC predicates, the first 3 being violent felonies, and the 4th being a single distribution of crack cocaine. The pre-sentence report referred to distribution in the singular as one ACC predicate. The onus was on the government at sentencing to specifically list all the predicate convictions it was relying on, and here it relied on only 4, 3 violent felonies and 1 single distribution. It would have been easy for the government to identify 4 distribution convictions as ACC predicates, yet it did none of the things it could have easily done. For example, in paragraph 64 of the pre-sentence report, it could have pluralized distribution and made clear that there were 7 prior felony convictions as ACC predicates. It could have listed by number 1 through 7 each of the 7 predicate offenses it was relying on. It could have explicitly stated that there were 4 distribution offenses and listed each of those distributions by date. But the PSR does none of these things, and the government never said at sentencing that it was relying on 4 distribution convictions. It quite simply wasn't.
Sorry to interrupt you, Ms. Darrow, but is this Hodge case on all 4s?
Yes, Your Honor. Hodge is about whether the government provides adequate notice by specifically identifying predicate convictions. And here the government did not provide adequate notice because it did not specifically identify.
Well, in your view, could Hodge be distinguished here?
No, Your Honor, I do not believe it can be, because the situation.
Let me ask you this. I know you said no. Why was the Hodge case not presented to and argued before Judge Curry before she made this decision on appeal? Hodge was decided 14 months before she decided her case, and they had it down there before her, and nobody brought the Hodge case to her attention that I can find. And do you know what happened there?
I do not, Your Honor. I believe that that's
you're the only one. You're the only one we got here to figure it out for us. First time
I understand, Your Honor.
The first time it's mentioned is when it gets up here on appeal.
Yes, Your Honor. And this court reviews the district.
And I think maybe your client, Mr. Benton, was pro se with the appeal. He had a retained lawyer down there who didn't tell the judge anything about Hodge. And the day after Judge Curry ruled against Mr. Benton, your client, his retained lawyer moved to withdrawal.
Your Honor, regardless of whether this issue is raised below, the question of whether the denial...
They may have looked at it and decided that this might have been no need for an appeal if somebody had the Hodge case. Did you know the government had confessed error on the basis of Hodge several months before Judge Curry decided her case in a similar case?
But, Your Honor, the government did not confess error here, and to the contrary.
No, that wasn't the question.
They confessed error here. They confessed error in another case before that.
Did you know that?
I did not know that, Your Honor, and I'd be happy to look at that case and give the court a better answer about that. But in this case, the government did not confess error, and to the contrary, it specifically identified convictions that it did not rely on the first time at original sentencing. And on appeal, the government says it meant to identify 4 distributions, but concedes it didn't provide perfect notice. But even accepting that the government meant to identify...
But it says it disagrees with Hodge's decision. It thinks the Hodge decision is wrong. They put that in a footnote in their brief.
That's correct, Your Honor.
What they're going to do about it, I don't know. When Hodge was decided and it's locked in the Fourth Circuit, it's the law that we have to deal with, and you have to deal with, and the government's counsel has to deal with.
That's absolutely correct, Your Honor. And the government concedes it didn't provide perfect notice, and imperfect notice is not adequate notice under Hodge. The government has to clearly and explicitly identify which convictions it's relying on, because the defendant cannot be left to guess what predicates the government believes are ACC predicates. And in fact, that's exactly the situation that Hodge meant to avoid. In Hodge, this court said that it would undermine the adversarial process to require the defendant to identify potential predicates that the government perhaps hasn't even contemplated. And as the court explained, it would place defense counsel in a precarious position if the burden was shifted improperly to defense counsel to identify predicates that neither the probation office nor the government had contemplated, likely to the defendant's detriment. And if the court were to accept the government's argument in this case, it would place the defense counsel in exactly that untenable and frankly unethical position of trying to do the government's job for it and identifying potential predicates it had not clearly and specifically identified as required by Hodge. Hodge says that this is unacceptable. If the government does not specifically list the convictions it's relying on, it can't do so on collateral review for the first time. There has to be certainty what predicates the government was relying on. And here there quite simply wasn't. The government never identified for distribution offenses at the time of the original sentencing, and the PSR did not do so either. And for those reasons, Your Honor, we respectfully request that the court hold that the district court erred in denying Mr. Benton's 2255 motion and remand the case for further proceedings. Unless the court has questions, I'll reserve my remaining time for rebuttal.
Thank you very much. Mr. Dior. We don't hear you.
May it please the court. My name is Rhett DeHart. I'm the acting United States Attorney in the District of South Carolina. Judge Motz, Judge King, Judge Harris, it's a pleasure to be before you again. In response to Mr. Benton's argument, I would note that the Hodge case is distinguishable in at least two respects that I would like to discuss with Your Honor. First, in Hodge,
why didn't you all bring it to the attention of Judge Curry before she ruled?
Your Honor, I'm the United States.
The Hodge case was decided 14 months before Judge Curry ruled, and you all filed a brief and you didn't mention it. And the other side filed a brief and didn't mention it.
Yes, Your Honor.
And Judge Curry wrote an opinion. I mean, nobody's looked at in South Carolina until it got up here. In the South Carolina proceedings, Hodge was not a factor.
Yes, sir.
It's the factor. And as Ms. Darrow says, it's hard to, she says it can't be distinguished, and you say it can. And,
yes, Your Honor.
But in the Brisbane case down there, you confessed error based on Hodge.
Yes, Your Honor. If you would allow me to finish, I can distinguish Hodge, but to answer your question, you know, I'm the United States Attorney. It was Mr. Benton's defense attorney to bring, if they thought Hodge somehow helped him, it was their job to bring it to
No, you are the United States. You're the United States Attorney. I know you're the United States Attorney. And as United States Attorney, you have a duty of candor to the court, just like every lawyer that stands up before the court. You have a duty of candor. And the Hodge case is a published opinion of this circuit. It was decided 14 months before Judge Curry ruled, and nobody brought it to her attention. I have heard this a satisfactory explanation. Because you knew about it, your office knew about it, you had to, because you confessed error based on it in the Brisbane case, which was set for argument here.
Yes, Your Honor. And again, I would respectfully suggest that that is, you know, had Mr. Benton's lawyer below brought it to our attention, we would have addressed it there. I can't speak to specifically why it was not. What I can speak to, Your Honor,
Counsel, sorry, just before you get to Hodge, sorry. But you are asking us to review this de novo. You've never argued that defense counsel's failure to bring it to the district court puts us under any other standard of review. I mean, your brief says we review this de novo. Okay.
Yes, ma'am. And Judge, Judge King, I would like to distinguish Hodge in two respects. And in Hodge, the pre-sentence report, the criminal history section was divided into two sections. It was an unusual PSR. In Hodge, there was one section that was for exclusively ACCA predicates. There was a second criminal history section for all other criminal convictions. And on collateral review, the government attempted to substitute after Johnson a conviction that was obtained and located in the criminal history section for non-ACC predicates. And the Fourth Circuit understandably noted that essentially the government was trying to use a latent conviction. By contrast, Mr. Benton's pre-sentence report had one criminal history section that listed all his adult criminal history convictions together. And in paragraph 64, it designated the distribution of crack cocaine as an ACC predicate. And in paragraph 74, it makes clear that he was convicted of 4 counts of distribution of crack cocaine. Now, I know my opposing counsel suggests that that was insufficient notice, but as a practical matter, there was no need for the pre-sentence report from Mr. Benton to list all four of the distribution of crack cocaine offenses as separate predicates, because he had 3 other ACC predicates in 1998. I mean, who are we fooling here? At the time, he had 7 ACC predicates, so it didn't really matter if the distribution of crack cocaine was listed as 1 ACC predicate or 4 ACC predicates. So that's one way to distinguish.
But in Hodge also, no, I don't think that distinguishes Hodge at all. This happens all the time, that the government thinks it has enough, so it doesn't add additional ones. But I thought we said in Hodge, doesn't matter, like either raise it now, or even if it's superfluous, or you lose the chance to rely on it later. So you're saying Hodge only applies if the government, I don't know how many, like if there had been 3, then Hodge would apply, but because there's 4, Hodge doesn't apply. That's your view?
I would suggest
if it had listed...
a more common, forgive me, John, I would suggest a common sense approach to this. When in 1998, Mr. Benton had at least 7 ACC predicates, there was really no reason to list all 4 of these distribution of crack cocaine offenses as 1 or 4. What difference does it make? He had 3 other ones. As a practical matter, why does it matter?
Well, I think we said in Hodge, it absolutely matters, because he's not on notice that if he's ever going to contest this, he has to do it right now. And can I just also say that I understand that the district court on habeas did the analysis to make sure that these really were 4 separate predicates under whatever our 5-factor test is. But, you know, whenever there's 1 arrest, like that's going to be a question. Are these really separate predicates or not? So I don't think we can just say, like, who are we kidding? This is 7. There's a question as to whether it's 4 or 7. The district court answered it on habeas, but what we said in Hodge is that's not sufficient. It has to be answered on direct review when the burden is on the government and the defendant has a right to counsel, not later on habeas. That was the whole point of Hodge.
It was, Your Honor. But let me approach this from a different angle. To what end are we here? What is Mr. Benton's purpose? And I would like to cite the Fourth Circuit's opinion in United States v. Rumley. We put it in footnote 6 in our brief. But in Rumley, the Fourth Circuit just last year made clear that Hodge is limited to cases on collateral review. So in Rumley, the district court granted the 2255 based on Johnson, vacated the sentence, and granted a full resentencing. What happened there, Judge Harris? Well, the probation office modified the pre-sentence report and designated another conviction as an ACC predicate that wasn't designated earlier. And the district court gave the exact same ACC sentence. So I guess my question is, to what end is Mr. Benton here? So just hypothetically, if this case was remanded back to the district court, Judge Curry has already found, and I'll point, Your Honor, to Joint Appendix 185 and her order denying Mr. Benton's 2255. Quote, each of the 4 counts of distribution of crack cocaine is a separate serious drug offense predicate for ACCA purposes, unquote. Now, what's the point in kicking this back when she's already made that finding? And, Your Honor, if you look at paragraph 74, please, Judge Harris, don't get caught up on the fact that there was 1 arrest. If you look at paragraph 74 in his original pre-sentence report, Mr. Benton distributed crack cocaine on 4 occasions over a 4-month period to an undercover law enforcement officer. There's no question those are 4 separate.
But the 4 of them were counted. The 4 of them only counted as 1, and Hodge undercut all that. and you didn't cite it to the district court. And now you come up here.
Yeah,
and
I
in your
didn't.
brief, let me on the page 16 of your brief, and footnote 3, you say the government respectfully preserves its objection to Hodge. Hodge's analysis conflicts with other circuits that permit the government to rely on convictions listed in the PSR, but not explicitly designated as ACCA predicates. So you understand that you saying it's wrong. And you say you're preserving your objection. You haven't made any objection to Hodge. None objection.
Your Honor, the Justice Department originally, obviously.
How would you have objected to Hodge? What I have a problem with, and it still hasn't been answered, is why it wasn't brought to the attention of the district court. I can't understand that. How you all not do that? If that's
well, again, I think that's primarily the responsibility of Mr. Benton.
Give you enough credit here. You can argue that it's not controlling. You can argue it's not controlling, but it's arguably controlling. And you were on notice of it, and you confessed error in the Brisbane case, and then you didn't bring it to Judge Curry's attention.
You keep telling
you
keep telling us that it was defense counsel's obligation, but I thought it was long ago established that the United States attorney has to see that justice is done, and you have a wider obligation than defense counsel. You have to tell the judge what the law is. You can tell her that you don't think it's the right law and you would rather go with other circuits, and you can distinguish it. But you have an obligation to tell them what the law is.
You're quite right, Your Honor. And to the extent that occurred, it was a innocent oversight. I'm certain that my colleagues who handled this below would never mislead Judge Curry. And but I'll go back to what I said to Judge Harris. It seems like a terrible waste of judicial resources.
Well, you see, I would say, counsel, I don't really understand that argument either. I mean, you can say that you think that there's just an enormous amount of evidence against somebody, but he was never provided with his constitutional rights. Well, what difference does that make? He's going to go to jail. He's a really, really bad person, and we should overlook that. But the law is the law. It gives people rights. We're supposed to follow.
Well, let me take a different tack, Judge Motz. Okay. It may save everybody time here. Under the concurrent sentence doctrine, I would ask the court to decline to review his ACCA sentence. And it bears repeating that Mr. Benton is serving 3 separate 420-month sentences for 3 separate convictions: for a drug trafficking conspiracy, for PWI crack cocaine, and for this ACCA firearm offense. So even if for some reason that y'all found the ACCA sentence was infirm, what difference does it make? He's serving
Counsel,
2 other 420 months.
It seems to me that's a very, very, very good reason why the government would not contest the argument here. I mean, I just don't, why didn't you confess error? If it doesn't make any difference?
Your Honor, like I said earlier, I do think Hodge is distinguished from this case. Now, I grant it's a fine distinction, but I do think it's distinguishable. But I go back to what I said to Judge Harris earlier.
If you think it's distinguishable, and why did you say on appeal that you thought it was wrong?
That was the Justice Department.
Reportedly preserved your objection to it. And you had no, but you didn't make an objection to it, but you preserved you preserved your objection to it. I don't know what your objection was. And you also said, well, you acknowledge that one panel of this court can't overrule another panel in citing a case like, as if you wanted us to overrule Hodge. We can't do anything about Hodge.
In response, you keep saying something about the Justice Department. We never let you get you. Is the Justice Department planning to take cert on Hodge? I would have thought the time had come and gone.
It is, Your Honor. I couldn't finish my sentence, but my point was the Justice Department initially opposed the court's decision in Hodge. We're not going to seek cert on
Well,
that. And that was a
Hodge-
different U.S. Let me finish, Judge King, please. I'm the U.S. attorney in the District of South Carolina. Hodge originated in North Carolina. I don't want to speak for them, but we obviously agree that it was wrongly decided. But again, I go back to this. What difference does it make? He's serving 3 separate 420-month sentences. So if you kick it back to
Counsel,
Judge Curry,
can I ask you about that? Can I ask you about this after Judge King?
I'm sorry.
Yes, ma'am.
No, you go, Judge King. I'll remember my question.
Hodge was the law, and you all didn't cite it to the district court. And you tell us that you think it's wrong. It was decided in 2018, and you tell us in your brief here in 2021 that you think it's wrong. And the Justice Department didn't file for cert that we know of. Nobody's ever said it did. I haven't personally investigated to see that. But I'm just befuddled. I thought y'all were going to come in here and explain that today. Because you confessed error in the Brisbane case based on Hodge. And I can't see a distinction between the two.
they are very close, Your Honor. I can see that Brisbane in this case are very similar.
And you confessed error in the Brisbane
you had a question?
A month before you filed this brief.
I'm sorry, Judge Harris, did you have a question?
Oh, can you explain that first? Why
I couldn't understand Judge King. I'm sorry, if you can repeat the question.
You confessed error in Brisbane, and it's from, I gather, the same office, and yet you're not confessing error here. Can you explain that?
Well, I think in this case, given the fact that Judge Curry, when she denied Mr. Benton's 2255, she specifically said each of the 4 counts of distribution of crack cocaine is a separate serious drug offense. Why would we concede that, Your Honor? This is such a waste of time. If it goes back, she's not, I mean, it's clear she's already made this analysis. So
isn't that a good reason to concede the error? I don't understand why that's a bad reason. From your perspective, that would seem to make a concession pretty much, harmless.
Well, what about
this? It seems like it would have saved us a lot of time. Okay, let me ask you my question about concurrent sentence. It's a discretionary doctrine, right? And this seems like sort of a weird posture for it, because I think we usually justify it by saying it's going to save judicial resources. We don't have to consider the question. But here the district court already considered it. And so the question is, should we devote enough judicial resources to make sure it was correct? Do you know what I'm saying? This issue is in the case. It's too late because nobody raised this before the district court to get it out. You could have asked the district court, don't bother figuring out whether these are sufficient predicates. We don't need them because of the concurrent sentence, but you didn't. And so I'm a little uneasy about the idea that we should use this doctrine that's designed to sort of save judicial resources or conserve judicial resources in this context when there seems to be sort of a big honking error hanging out there. And you're telling us now is the time to sort of conserve our resources and not correct it.
I understand where you're coming from, Judge Harris. I would ask you to consider both these arguments together. One, the fact that the district court has already found clearly that there are 4 distribution of crack cocaine offenses or 4 separate predicates, coupled with the fact that Mr. Benton is serving 2 separate 420-month sentences. You put all those 2 together, it goes back to my original question. What is the end game for Mr. Benton?
What is the
end game?
What is the end game for the government in not confessing error here?
Your Honor, we're trying to save judicial resources.
Save judicial resources, we wouldn't have had this argument.
But it's so fun. We're having such fun here. It's I mean, it's so delightful to be here. I guess I know this is a fine distinction. I think when you couple both the fact that the district court's already made this finding about sufficient ACC predicates, coupled with the concurrent sentence doctrine, it does seem to be.
The district court made those findings, Mr. United States Attorney. The district court made those findings without being informed of the Hodge case, which undermines those findings.
Your Honor, I would direct you back to United States v. Rumley. Your circuit, Your Honor, just last year made clear that Hodge is limited to just the cases on collateral review. So there's no question if this is remanded, it's going to be the same thing. I mean, Judge Curry's going to come in there.
But again, counsel, but Hodge, I mean, I guess you're consistent with your argument that Hodge is wrong, because Hodge itself turns on what you were calling the formality of who has the burden of proof and who is represented by counsel at what stage of the proceedings. For the Hodge court, it was really important that this get done not on habeas, but at the original sentencing, when the burden of proof would be on the government, and we can be sure that counsel will be, that the defendant will be well represented. So what will be different under Rumley when this goes back on remand is that the 5-factor test will be applied with the burden on the government and with the petitioner well represented, given that he has a constitutional right to counsel. And we said in Hodge that makes all the difference. So I don't understand how you can stand up in front of us and say, whatever, it's no big deal, without also saying, and Hodge was wrong. But now that I think about it, you are saying Hodge was wrong. So it does make a certain amount of sense.
Yes, Your Honor. And again, I want to go back to one point, that if it wasn't, we would have much less an objection of having a remand under Hodge if Mr. Benton wasn't already serving 2 separate 420
Well, he says that he thinks
he
he can get First Step Act relief on those, or at least that he's eligible, right? And if that's right, it will then become very important whether this is a 30-year sentence or a 10-year sentence. So I don't know that we have the kind of certainty we would want that this will never make a difference.
Yes, Your Honor, but I would actually like to address it if I may, Your Honor. It's interesting that for the first time in his reply brief, Mr. Benton raises the First Step Act. Your Honor, he has never filed a motion under the First Step Act. The First Step Act was enacted in 2018. It's almost 4 years later. Mr. Benton has never filed a motion under the First Step Act. That might be a good question for his counsel in reply. He had multiple opportunities to. He could have filed a motion for a First Step Act when he filed his 2255. He could have filed a motion for a First Step Act before he filed this appeal. So it seems like awfully speculative. I just asked the court, if he's eligible for relief under the First Step Act, why hadn't he filed a motion under it?
Well, we appreciate your help in forming our questions. Unless one of my colleagues has any further questions, I think your time has expired.
Thank you, Your Honor.
Thank you. Counsel, do you have a rebuttal?
Yes, Your Honor. Hodge sets forth a categorical rule that the district court cannot apply the ACC enhancement based on convictions identified for the first time on collateral review. The government cannot get around that very straightforward holding. The government cites United States versus Rumley, but Rumley actually supports our position, not the government's. In Rumley, which was decided after Hodge, the district court vacated the defendant's ACC sentence based on Johnson. At the de novo resentencing, the government argued that the defendant still qualified as ACC based on predicates it had not identified at the time of the original sentencing. And the district court did eventually apply the ACC enhancement. But under Hodge, the district court had to vacate the defendant's ACC sentence because Hodge sets forth the categorical rule that the ACC sentence cannot stand based on convictions identified for the first time on collateral review. It simply doesn't matter what is going to happen below, but Mr. Benton does have arguments that he would present at a de novo resentencing about why he wouldn't qualify as ACC, and he must be given the opportunity to make them. Concurrent sentence doctrine simply doesn't apply, as United States versus Charles makes clear. Just like Mr. Charles, Mr. Benton is eligible for relief under Section 404 of the First Step Act. So as the court has pointed out, the impact of this appeal would very much impact the Section 404 motion because he would be effectively denied meaningful relief if this court did not review. In terms of why Mr. Benton hasn't filed the 404 motion after he filed the appeal in this matter, It's unclear if there would even be jurisdiction after a notice of appeal has divested the district court of jurisdiction. Hodge dictates that this court must vacate the district court's denial of Mr. Benton's 2255 motion and send the case back to the district court for further proceedings.
Thank you very much.
Thank you.
Appreciate your arguments, both of you. Thank you.
Thank you.
We will adjourn court.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.
Okay, judges, I'm just removing